Morning. This meeting is being conducted pursuant to New York State Open Meetings Law, Public Offices Law, Section 100, etc. For purposes of this meeting, I am designating Julia Lee as our recording secretary. Today we have before us consideration of the following proposed amendments to Board Rules 113 and 117, and then to Board Rules 107, and then to Board Rules 101H. So why don't we begin with amendments to Board Rules 113 and 117. Chris, want to give us a brief introduction to what we've got in front of us?
Absolutely. The board's recent rulemaking has added specific conducts that violates Charter Section 2604B2 in the context of official fundraising and community board service in Board Rules Sections 114 and 115 respectively. These new prohibitions require some housekeeping to Board Rules Section 113, which appears to have been originally intended, when adopted in 1998, to contain all the rules interpreting and applying Charter Section 2604B2. Because that is no longer the case, the proposed rule before the board would reorganize Board Rules Section 113 into a rule that only covers the use of city time and city resources. The proposed rule would also amend Section 113 to codify advisory opinions pertaining to the use of city time and city resources, including advice on published work, teaching, and paid speaking engagements, as well as elected officials' endorsements of political candidates. Finally, the proposed rule would move provisions pertaining to accomplice liability, currently in Section 113, into a new board rule, Section 117.
So just one preliminary point, just to confirm, 117 is literally the same as old 113, was it D?
Are
there any changes at all in 117?
There are a couple of
Okay.
housekeeping changes in that simply to reflect, the.
It's on page 8 of example 1.
Yes, simply to reflect the language in the existing 113F, which is the current provision on accomplice liability, discusses subdivisions, refers to subdivisions A, B, C, or D of this section, and so that's cleaned up a little bit. But beyond that, there's no substantive difference.
But in substance, 117 is pretty much what we had before.
Exactly.
Okay, except repackaged.
Exactly.
Okay, maybe, as we often do, I think I have a comment on the statement of basis and purpose, and then and maybe collect any comments we have on that, then we can go into the, the rule. So on page 3,
Yes.
the statement of basis and purpose, kind of the paragraph that begins on line 7, excuse me, I'm coming down with a cold. When you say the board proposes amendments to 113 to codify advice given in 2 advisory opinions that reflect the board's practice, and then there are 4 bullet points. The advisory opinions are in the 3rd and 4th bullet points. I take it there were no advisory opinions that were codified in the first 2 bullet points?
Not specifically. I mean, there are some that certainly advice enforcement dispositions that involve that involve those conducts.
It's more a writing point. I would recommend
Yes.
revising this, breaking it up, putting the first 2 bullet points before, and then when you say the advisory
Sure.
opinions are codified, then actually have it immediately afterwards. Because
Okay.
I spent most of my time to figure out which advisory opinions are in the first 2. So it's a
Sure.
little confusing the way it's written
Yeah,
right
you
now.
might want to say to codify, comma, among other things, comma, advice given in 2.
Yes.
Or even just to break it up into 2 parts. Again,
Yeah,
in addition, we're going to do the social technology resources and the nonprofits, and then the following in addition to. Either way, but just to clarify, because otherwise it was a little confusing that the first 2 you were not actually
Yes.
putting advisory opinions. That's all I had on the statement of basis and purpose. Anybody else on that? Okay. We'll just go bit by bit. It has how many subsections? A, B, C, D, E, F. F. So looks like A, B, and A. Well, just go to any comments on subsection A? or B?
I have a comment on D.
Okay, we're getting there. Barreling right along here. C has a sub 1 and a 2.
Yes.
Okay. For C1 Romanet
Yes.
2, just confirming that those are all alternatives. I know it does have the or, that the proposed volunteer services advance the person of further purposes or benefit, that these are disjunctive.
That's right.
So
That's
just,
right.
okay, I don't know if you need to put that more clearly in the statement of basis and purpose, that you don't have to satisfy all three. It does say it that way, but maybe just to underscore that in some other place, that they're fully disjunctive. I think we're ready to go to D.
Exciting, you made it sound
Okay.
exciting. The D1, it says that the city title has to be one of several biological details. Is that
Yeah.
actually required?
That's advice that the board has given in connection with, for instance, a biography that appears on a faculty faculty webpage or something of that nature. It's paragraph 1 is not the only way to comply with the requirement. You can also comply by adding in paragraph 2 only having
So
your
it could
city
be the
title
one thing
plus with a
if you're going
disclaimer.
under that, gotcha.
If you have a disclaimer, then that makes clear that you're not speaking on behalf of the city. Or if it's just one of several biographical details, that also, given that context, makes clear that you're not representing the city in that published work.
I actually didn't think about that. So you don't have to have the disclaimer at all if you give more than one
That's right.
biological
There's an
detail.
or between 1 and 2.
Gotcha.
Yes.
Okay.
And biographical details would include your BA or JD or
Exactly.
MD or
yeah.
whatever.
Or if you're a part-time public
Right.
servant, your full-time position,
Okay.
that sort of thing.
Okay.
Or lives in Brooklyn.
That should go first.
More likely.
That's not how that works.
Any more on D? Or E? Don't hold your breath, I have something on F, so. We're up to F. I have a very, very minor point on F, which is really on page 8. Line 5, when it says, "The further themselves as a public servant." Since the point here is to use your position, I would modify that very slightly to say to their position as a public servant. In other words, not just I'm a
Yes.
public servant, but I am deputy controller, or I'm a public, the actual title or position. So
Yes.
I was going to have the language, or I'm not wedded to this very specific language, but the public servant is otherwise preferred to referring to their position as a public servant, or words like that to suggest what you actually are, and not just that you're a public servant.
Yes.
Take it that that's agreeable. Anything else on F or on 117? Okay, so to sum up, and I think we have a modest revising of the statement of basis and purpose to clarify where the reference to advisory opinion goes, and maybe a brief statement to clarify with respect to the item I flagged, that it be
Yes.
clearly clarified that those are alternative justifications,
Yes.
and this extremely modest tweak at the tail end with respect to public servant. So, based on that, I call for a motion that the board adopt the recommended amendments to Board Rules 113 and 117 as the final rules, with those three very modest modifications.
So moved.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Motion for adoption of the proposed amendments with the modifications as discussed as the final rules has passed. And as I always ask at this
Yes.
point, because after 5.5 years, I still don't remember what happens next.
Well, because this is the first time the board has seen this rule and has looked at the language, this will be now with these, with the edits that were discussed and approved, will be submitted to the law department and the mayor's office of operations for their review and approval. And assuming, as is generally the case, there will be some minor tweaks to the language, it will come back to the board for review prior to the holding of a public hearing on the rule.
Okay, great, thank you.
Thank you.
All right, next up, Chad, take a seat. Proposed amendments to the 107 post-employment. And again, why don't you give us kind of a brief overview in a sense of, this is a longer document.
Yeah.
So what's going on?
I'm gonna set the stage a
Okay,
little bit for
please,
this
yeah,
one,
great, great,
because this is obviously a very large and challenging rulemaking. It involves 31 advisory opinions. Chad's done a really marvelous job being the lead attorney on this project. So I wanted to, at the outset, emphasize there's no reason we should think that we'll get through this in 1 or even 2 board meetings. This is a complicated and important subject matter, so we should take our time and get it right. The proposed draft rule does 3 general things. 1, it incorporates some definitions from advisory opinions. 2, it articulates a standard for granting post-employment waivers. And 3, it codifies a couple of AOs that establish this consulting back theory that the board's had for quite a while now. We've received comments from a couple of individual board members that we have found actually very helpful and make us want to make some revisions to this. But we didn't want to make a bunch of revisions and sort of drop them on everybody too soon before this meeting, and we thought about maybe pulling the item to bring it back with revisions reflecting those comments for a future meeting, but thought everyone's read this, and so it'd be better, we thought, if we got general comments from the board about this and tried to incorporate everything and come back with the next draft of this. And sort of to that end, I thought I would suggest, though we can do this however the board wants, that we kind of focus on more big picture conceptual things at this point, and we can get into the wordsmithing and the weeds of the things once we have a draft that more accurately reflects the big picture view of the board. But we're happy to take whatever comments people have. I am happy to summarize the main points of the comments we received from individual board members and share some staff thoughts about those, if that seems like the appropriate next step, or we can do it some other
So
way.
I have 2 thoughts. One is if it's kind of global, then do it front. If it's on specific sections, you might want to do it when we get to those specific sections. So I
Okay.
don't know. So within that
Yeah,
guidance, if it's the overall structure, something like that, then do it now. But if it's to section C or something,
Yeah,
do it when we get to section C.
As you'd expect, most of the thoughts are about section C. So I can bring them up as we come along.
And I'm also, I think, gonna forego my usual thing of going through the statement of basis and purpose and go directly to the rules, I think, because if the rules change, the statement will change, and this is one where I think, whereas I think the prior one, the rules were, the changes were not as significant, or this is actually virtually more or less brand new. I mean, it's not truly brand new, but it's close to brand new. So maybe we'll skip over, unless somebody really has something that really leaps out of them at the statement of basis and purpose, I just assume focus on the rules themselves.
Sure, maybe I'll just say
Well, if there
one
was a
thing.
comment on that,
Yeah,
why
there
don't you
was
say that?
one, which I'll just say very briefly, a suggestion that in the statement of basis and purpose that regarding the waiver section of the rule, that requests essentially that staff provide the citations and explanations of where those concepts are coming from advisory opinions. We've gone back and done that, so the next draft will include a detailed sort of history of that.
Yeah. And I think even more globally, and I think this has come up at prior, as we've gone to this sort of a major rulemaking process in part designed to codify AOs, I think as a general rule, that's a good idea. And for future rulemakings as well, as whether it's in the body of the statement or in footnotes, I think wherever possible to reference the advisory opinions from which it's coming, from which the proposal is coming is always a good idea, because that is, it helps to sort of explain where these things are coming from, and also I think reflects one of our goals, which is to heed the admonition of the city council and move into a more codified setting, to pull all those AOs into an easier to read place. So I think that's a great advice for this, and I would say for future rulemakings too.
I guess I did have, and I don't know where the statement of purpose and the rule discussion will begin on C, but to build off of the AO comment, adding more detail and specificity. The other comment that I had was taking a step back, and you know, this has been an issue that we're always dealing with, this waiver issue. And I'm glad, I appreciate all the hard work you're putting into and trying to figure out how we can build a framework. The one sort of conceptual issue that I had with the statement of purpose, and then maybe it plays out in the rule, is that we've had this historic exigent circumstances test, or four-part test for almost 20, 25 years. And we had that 08 AO and the 2012 AO that tried to build a framework, right? And so the question I have for the statement of purpose, and maybe it'll be more discussion in the actual framework of the rule, is how much do we have to explain to the public and through the charge that we got from the city council? We have to say, look, this was our precedent that we've been doing for a while. There's a four-part test, and then if you were a public-private partnership type issue, you didn't have to meet all four, basically. And that was the general approach. And now we're taking a not totally different approach. We're taking some of those aspects and building into the new framework. We're losing some others, which one we'll talk about later. But in terms of, as a rulemaking body, how much do we have to explain that this was our prior framework, and now we're departing from that prior framework, and here it is?
You don't have to explain that in the text, in the statement of basis and purpose, but as a historic matter, it might make sense to include some sections about that. The statement of basis and purpose really exists to explain the rule being enacted, but to the extent that that historic information might be helpful in contextualizing some of the decisions that the board reaches sort of further on in the statement of basis and purpose or in other parts of it, that's certainly not a problem for us to include. There's always a pressure for a briefer statement of basis and purpose, but I think the board has been producing longer ones in part because we're not just creating new rules, we're explaining things that the board has already done. And the law department's very supportive of us having these more extensive, more comprehensive statements of basis and purpose to achieve that. So that's definitely something that we would be able to do.
Okay. So why don't we begin with A, post-employment appearances. I mean, maybe even more. I take it, so we have four subsections, right? Post-employment appearances, the date of termination of city service, of which we've had some recent issues, waiver, which is the largest part of this, but also, and then the consulting back, which is something which has emerged as significant in the last more than a few years. And it's probably something that wasn't fully thought about when the charter was first adopted. So I think that strikes me as a reasonable structure, just to comment on that. And if anybody had any comments on any suggested changes in structure, now would be a time, but I think that's a good structure. And obviously most of our focus will be, I think, on the second two, and maybe particularly the third one. I had a couple of comments or thoughts on A, on post-employment appearances. One is on A1. It's sort of funny that it goes directly to the thing that's not core. In other words, appear before includes compensated communications with a city or commission on which a representative of the former city agency sits. Might be better if we also put in the core, what the basic appearance, I would include the basic prohibition, which I think is actually in the charter itself, and maybe just restate it there, because otherwise it seems like we're only putting in the marginal thing and not the core thing. And I don't think there's any administrative law problem in restating charter language in the rule itself, so that people see in one place that includes, this is what an agency is, or this is what an appearance is. We don't actually define appear. This is what we do it. We do it by negative, but I would maybe borrow a little bit from the definitions of appear and agent that appear, no pun intended, in the charter itself, just so that otherwise there's a kind of funniness to that. It seemed kind of stray that you mentioned this odd thing, but not the core thing.
There's certainly no
From
prohibition.
6013 and 4, I guess, is what I was looking at.
There's no, wait, I'm sorry.
No, it's A1, but I was looking at the charter
Oh,
provisions.
yes, sorry, yes.
The charter provisions.
Yes. Right, for 2604, D2, oh, for the definition of a
Right,
period, you
and
mean,
it
yeah.
just, it just struck me as, if somebody was to look at what do I mean by post-employment appearance, this is sort of, well, it's also this, it's
Yeah.
also B. It'd be nice to say the core thing.
So as we have not been repeating anything from the charter in the rules thus far. Our practice has been to not ever repeat what the charter has, but only to add things to it. The idea being that this is to create a leaner document that's only adding things and
Right.
not sort of creating any sort of confusion there. That being said, there's no prohibition on repeating such sections. And maybe I might suggest for this that that we could probably capture the idea of the prohibition here in the phrase, perhaps.
Yeah, I'm not calling for specific repeating of charter language, but it was more so that if I'm a lawyer, as it happens, and I want to look up what a post-employment appearance, what appear before an agency means, what I'm getting here is kind of, it's like if this was Webster's, it would be like the fourth definition. And I kind of want to get the first one, and have it all in the same place.
Well, you get it all in the same place, though.
Well, no, you have to go to the, you don't get it all in the rule, you have to go back to the charter to get, so you have the charter here and the rule here, and I'm saying put it all in one place.
It goes to, I guess, one of the overall problems I have with this rule is distinguishing between a rule and guidance. I mean, there ought to be a place where you can go, and there may well be, where the board has produced guidance documents, educational materials, where it tells you what a post-employment restriction is, and where you, with citations as to where to find the reference to those. I think it's here and it's in some other parts of this where I think there's a lack of a boundary between what is a rule, what is it that we are actually acting on that prohibits certain conduct and defines that, as opposed to providing guidance. And I think it goes through here and it goes through a number of other places as well. I mean, in this one rule, I don't want to skip it, where it says, social communications with an employee of a former agency is permitted. I mean, that's not a rule. I mean, that is something that we ought to educate people about. But I don't think we are declaring here that you can have a social communication or talk to somebody about personal financial matters that, I don't know, that sort of pops up here, that have nothing to do with your agency.
I had a reaction on that one also. Those three items seem rather, both very specific and very random. And I actually would have been more comfortable if you had just put a period after the word matters on line 16 and actually didn't give the illustrations, or maybe the illustrations in someplace else, because it just seems really random. But as I said, very, very specific about their personal finances and political endorsements, and also like, surely there are other things, I know it says included but not limited to, but it sounded like it was the summary of 3 specific advisory opinions, which I'm sure it is, although they're not referenced. And maybe put more in the statement of basis and purpose as an illustrations of this, but it struck me as kind of funny in the rule. And hold on one second. I mean, this is less about the substance and more about how it reads and the kind, and maybe it's really Jeff's point about the nature of the document. And even as we codify the advisory opinions, maybe because the specific ones have been on kind of random topics, it felt kind of random.
Right, those sections were included because those are the frequent topics of discussion, but it does make sense as a point that the board is able to interpret this non-city matters to include those things, that it might not necessarily be beneficial to include that specifically in the rule, and to end that sentence after matters, even though we're not necessarily wordsmithing, would make sense to us.
And maybe in the explanations up front, A2 says, non-city matters, in prior advisory opinions, the board has concluded that X, Y, and Z fall into that category. And which gives the guidance that Jeff is looking for.
That makes complete sense. It's motivated mostly by us working with the materials that we have in the post-employment context and just trying to be as comprehensive in the rule as possible. But there's no reason why that has to be here as opposed to other places.
Yeah, the Board of Funding gets to synthesize the
Yeah, that's right.
principle rather than simply
Yeah.
repeat every
That's right.
opinion.
Any more on A?
And then where does that guidance go?
Well, in this context, we would propose to include some of that in the statement of basis and purpose, and then we would incorporate it into other educational material that the board might produce.
Okay.
It's already in
So
all of our
we keep it in the
post-employment
statement of
education
purpose where it
material.
is
Presumably
now,
it'll be in this book.
and then put it in the book.
It,
Or FAQs that are online. or-
exactly.
I mean, I don't want to micro-write it.
Yeah,
but
we've-
presumably in those kinds of documents.
Exactly.
Yeah, this rolled out quickly, in part because this is advice that we give frequently to people in many contexts, so.
But then, I agree with you, Jeff, but then we're not codifying those AOs, basically.
We were able to incorporate the principle of those AOs through reference to say that these things, which are non-city communications, are being included. We're able to codify the principle of those AOs. It's just that the specific context, the board's specific interpretation of non-city matter, that those specific contexts won't be incorporated. So the legal principle is being incorporated, and sort of the legal principle of the advisory opinion is being incorporated. It's just that the sort of the hyperspecificity of Romanettes 1 through 3 won't be included.
I was thinking you could group those specific AOs in the statement of purpose, which I thought was very long.
Yes.
And not to make it more wordy, but to make it easier, I guess to Jeff's point on guidance, like, and I don't know how you can do it, but since these are examples of communications not related, or not related to different, and then just list them or something like that.
That's what we'll
And
do.
examples of where we have it in
Yeah.
other places, and then just list them.
Yep.
I found the paragraph with just the list of random AO numbers
Yeah.
was very long, and it would have been helpful, or will be helpful, I think, to the extent there may be repeats, I guess, they'll appear in different sections. But to put them under the topic that they actually relate to in the rule, and just group them that way. And if someone took time to count, there probably will be more than 30 listed, but it's the same 30, they just might appear under different sections, topics.
Okay. B, a determination. This actually seems pretty straightforward, but
I was confused, maybe I shouldn't say I was confused then, but I was confused by B1, where it says, or receives benefits conditioned upon current city employment after resigning, retiring, and being terminated. I know we've had some examples.
Right.
But I'm not sure that I get the current city employment after, are we talking about severance? Or
No.
something, or what are we talking about?
So the idea being that, and most recently in 2019-1, the board has had the opportunity to evaluate a public servant who stopped performing city work and that was on a period of sort of extended
Right.
vacation while
Play
still
out your
retaining
leave.
Very extended.
very extended vacation for a period of months before triggering his resignation and receiving what we would call that terminal leave. And
So he received benefits conditioned upon current city employment.
that's right. He received health
After-
insurance and commuter benefits and pension benefits and things like that during the first 6 months. And then the second 6 months was just him receiving the balance of his unpaid salary, the unpaid vacation time. And so the idea would be to distinguish it, that it has to be the later of the last day you worked or the day you're receiving these benefits associated with city employment. And it would, just removing current,
no, the current is right. because
No, I
otherwise-
said it was
because
the
you-
condition.
Because if you're getting retirement, if you're getting a pension,
Right.
it'll go for 30 more years,
That's
so it
right.
has to be current.
that's right.
It's the stuff that's
Right.
accruing into your pension.
Right.
Or the equivalent that we're talking about.
Yes.
Yeah. The current is crucial.
The current is.
Yeah, yeah. Any more on B? Okay, C. And some parts of C have, maybe we may need to structure a little bit. Well, it's essentially one giant thing with lots of subparts. I had a question about the block text in the kind of first paragraph, 11 to 17. Especially after 13 to 17.
Yes.
If it determines both that the proposed conduct does not conflict with the purpose and interests of the city, and then it benefits the city, is it ever gonna be the case that something cannot conflict, that something could conflict and also benefit?
So
I mean, so my thought was that if, isn't does not conflict subsumed within benefit? I mean, you could, a benefit is a higher standard than not conflict. But if it benefits, then clearly it doesn't conflict. So I don't think I think both doesn't make sense. It's either the higher or the lower. If it's the higher, you don't need the lower. If it's the lower, you don't want the higher.
We would propose to remove the discussion of benefit and only include the discussion of not conflicting,
fine.
which would be a closer parallel to
Yeah.
the language in E.
Right.
And that would, one, it would have the virtue of making this paragraph shorter, and two, it would just simply, it would make it
Right.
clear that where the board is still acting within its discretionary power pursuant to E, that it's not binding the board to a separate, higher standards being articulated somehow differently.
That's fine, because otherwise, right, because that was my confusion. Those are two different standards and one is higher than the other.
right, and
So it doesn't have to benefit the city.
Right, the board's authority to issue waivers is pursuant to E, where the standard is does not conflict. And the thinking about the factors is that these are factors which the board might look at to determine whether or not it does not conflict.
Right.
We wouldn't want to,
It's not a requirement.
yeah, exactly, it's not creating an additional legal requirement that might cabin the board's ability to evaluate these requests pursuant to E.
right, that was certainly the intent in our drafting of this, and both of the board members who provided us with individual comments expressed concern that maybe this is written in a way that seems like it cabins the board's authority to issue waivers more. And I think that that's partly a result of that phrase that we've just said we'll remove about benefiting the city there, but also because the next sentence says that the board will consider the totality of circumstances by weighing each of the following individual factors. What we really intended to do and would propose to revise it to reflect is that it would say that the board would consider the totality of the circumstances, including but not limited to the following factors. The idea being, and if you'll permit me just a minute to sort of talk about this, while the board has looked for recent years to this so-called four-factor exigent circumstances test, that is a test that was deduced or synthesized or found by a board and written out in an AO, really to try to create a very difficult standard for granting post-employment waivers. This is a board that viewed post-employment waivers as being things that should be given out extraordinarily rarely, and created that standard for that purpose. When looking back at all of the advisory opinions that preceded that really comes into fruition in the 2008 and 2012 opinions. When looking back at the opinions that preceded those, we found that, in fact, there were times when the board was much more flexible and looked at a variety of other things. And so we've tried to sort of canvass all of the advisory opinions on this subject to create a list of factors that actually better represents all the things that the board has historically looked at in granting or not granting post-employment waivers, so that we capture all of those so that the public can see what the board has looked at, and helping to provide some guidance to the board about things to consider when doing this, but not cabining the board in that case, so that the board will look to the totality of the circumstances. The binding test is the one in the charter.
If we become more strict over the years, and we now have that four-part test, why could we not adopt that? I mean, maybe sometime in the past, the board was more permissive, but because the board was at that time, doesn't mean that we have to do that today. We've articulated the four-part standard. It's a difficult standard, and we feel, I think, around the table that it should not be easy to get a post-employment waiver. So why not? Why try to capture all that we said before? I mean, the thinking evolves, and the board is now far more restrictive. So why not do that? And again, going to my point before about guidance rather than rule, I don't know whether putting each of these things in the rule, because these are things the board looked at some point, is the best use of rulemaking, rather than have some place where people could say, well, here, I'm interested in getting this post-employment waiver. Here's what the board has done. This is the universe in which this has occurred, if I want to ask for one. Or we, in evaluating whether there should be a post-employment waiver, look at those. But whether they all have to be set forth in a rule, I don't know. And if we have articulated quite strongly over the last few years a 4-point test that has to be met, why not put that in? Why not make that our rule today in 2020?
Sure. So if you don't mind, I'll take those. I'll take those in reverse order. The reason I think to set out in this rule what things the board will look at in evaluating requests for post-employment waivers, I think is worth doing for at least a couple of reasons. One is I think it's helpful for the board to communicate in a rule, as it has done in advisory opinions, what things it will look at, what things it thinks are critical things to evaluate in terms of making a determination about granting a waiver, both for the people who are requesting waivers and for the public generally. Second on that point, the board creating a standard for granting or evaluating post-employment waivers is one of the specific examples that the city council raised in its public hearings when it was considering revisions to the advisory opinion section that has caused the board to start engaging in these rulemakings. With regard to why not just codify the 4-factor test as a strict test, my response to that would be I think, and obviously welcome everybody's thoughts about this, but my experience has been a couple things in that regard. One, it seems to me in my time at the board that the board has not infrequently struggled to fit otherwise appropriate post-employment waivers into those 4 factors, that there are worthwhile waivers and that it's that don't quite meet that test, and that it's worth acknowledging that test is in some way not working for at least some set of those post-employment waiver requests. But others might disagree about that with me. Another is there are a number of post-employment waivers that some of these factors are attempting to address that are handled as routine chair matters, including circumstances, for example, where a public servant has worked for an incredibly brief period of time at their city agency, essentially sort of a false start of public employment. Why would you hold them, to the strict post-employment restrictions when they only took a job for 30 days or, worked as for example, a substitute teacher on only, 50 scattered days over a school year? The law would suggest that the restrictions have to apply, but it seems that a waiver would be appropriate for those people because their participation in public service has been so minor that it doesn't seem like they would have gained the kinds of influence or connections that the post-employment restrictions are intended to prevent people from misusing. So there are some of these factors are getting at things like that as well. So those are just some thoughts about that.
And if I can piggyback off of that, that's sort of what I was previewing and alluding to at the beginning of the conversation, is maybe starting with the existing approach that we had and to having the discussions whether or not we need to rejigger it, what worked with the prior standard and what didn't. I reread that 2012 AO that you guys sent me. Thank you very much for that. And that AO pointed out that the first factor is almost meaningless, the relationship between the employer and the city. So I think that's a good argument for why should we have that, you know? But then there's a third factor that for me has always been the most important one, or at least in my view, the likelihood of harm to other organizations, like the competitive the competitive issue, the anti-competitive protection. And that's no longer here. I understand we tried to express it implicitly, but that's the kind of thing I think to go into Jeff's point, like, to me, that's critical. I think we have to have it here somehow. And that's a sort of like broader rule-based sort of conceptual issue that I think should be here. I think when we tried to articulate it, I think what you were getting at, Chad, was in 7 and 8, I think, was trying to get at that anti-competitive point, but I don't know if it really gets to the broader sort of regulatory concept that Jeff's talking about.
It might not be a strong enough articulation of that sort of principle, and we could look at more strongly incorporating that into some of the existing factors, or including it as a factor.
Right, and I don't mean to rush there, but just to continue Jeff's conversation, we should have a broader discussion of whether, you know, do we want to adopt the 4-factor test? Because in that one, if I remember Erica, we would always be like, what is it again? And just to be clear, you have to meet all 4 factors. And if you don't meet all 4, then you don't get the waiver, unless it's a public-private partnership relationship. And then if there's closer to a vendor, we lean more towards the 4 factors. If it's closer to more of a unity of interest, I can't remember the specific terms, then we were more towards granting the waiver.
Yes.
And I just found that the whole, I mean, I remember, Eric, and we would always have issues with this, because it was difficult to apply, because we did feel cabin in some certain sense. So I welcome the opportunity to revisit it, but I think maybe we should start with having a conversation about the old test, see whether or not we want to codify it, or how we want to adjust it.
It would be described probably as, we might say, 4 factors on a sliding scale, where you have the 4 factors where all the way on one side of the scale, somebody must meet all 4 factors. All the way on the other side of the scale towards an entity that is a true public-private partnership,
Right.
somebody might not necessarily be required to meet all the 4 factors, and there's this intermediate zone in which an entity is described as a hybrid, where some level of intermediate scrutiny is applied.
And then there's examples of the many, many, many factors that are included, but it seems odd to list every single factor. I've never heard of, I mean, I guess there are, you know, the IRS has like a 20-factor test or something. It just seems odd, the more factors you actually list, the more it seems like, well, there probably are other factors that, so I don't know if they could actually be subsumed within the 4-factor test, and then somewhere it says that these are examples of how this has played out.
The principle of breaking out sort of the 4 factors into more factors would be in part to guide requests to the board.
The easy
That-
ones, right, that's.
to provide sort of trail markers so that a person who is applying for a waiver would be able to look down the list and provide
Like
in
the
the request.
30-day example, that's actually a good one, because why should someone think, oh my goodness, I worked for 30 days and then I quit, and I have to go through this incredible factors test, you know, that seems pretty simple.
Quick question, what are the 4 factors again? And I can't find it in the statement of basis and purpose.
That was my point earlier.
The 4 traditional factors?
That's one of the things that we clearly need to,
It's the nature of the entity and its relationship with the city, that there's benefit to the city.
The nature being that it could be a not-for-profit versus a for-profit.
Well, it might be more clearly articulated as whether or not it's a vendor relationship or a public-private partnership.
Okay, okay.
More not-for-profits are more likely to be
Right,
said to
okay.
have
Okay.
public-private partnerships. The benefit, the uniqueness
Right.
of the requesting public servant, and the potential harm to the subsequent employer's competitors in sort of the field.
So, the uniqueness shows up in Romanets 4 and 5, although they're 2 different kinds of uniquenesses.
Yes.
And maybe that's worthwhile. The competitive doesn't show up at all. And I suspect this, and I think 1, 2, and 6 maybe is a version of the vendor partner version. And 1 and 2, I think, are sort of more general restatements of the general idea. So we're trying to figure out what these things are and where they come from.
Right.
And to what extent are we, I'm not wedded to the four-part, if we could turn it into something that has more bite, and it does seem to me that items 4, 5, and 6 are ones that we actually are, or the ones we're actually using a lot of the time. And so, as the four-part test, as it gets applied, actually turns into other things. And 4, 5, and 6, and I think in some sense, 2 almost restates the overall test. 2 is almost a conclusion. Are we better off or not?
Goes to the benefit.
Right,
which is
just the
already
benefit,
a
and the others go to the need, well, but the benefit is the unique technical. I mean, benefit is just come to a conclusion. I think the ones that seem to have bite are 4, 5, and 6.
So if two is just intended, with regard to the benefit, to just
Yeah.
make it clear that when you're looking at what the benefit of the arrangement
It has to be
is.
to the city.
Right, and making clear what you're distinguishing that from.
Right,
that-
okay, I mean, the other thing I thought of in terms of organizing this is, a couple of these things are more like negatives than positives, like, we never actually think about 3 and 10, except on the outside, we might wanna break down as a separate subsection, that we're less likely to grant it if there was some prior negotiations and they come late. The 3 and 10 seem to have a different dimension, a different axis than the others. I mean, it's written in the positive, that you didn't delay and that you did recuse. But I think we really tend to use it in the negative. If you did delay, you did recuse, that's gonna count against. And I don't know whether it's worthwhile to have a 1 and a 2 in this area, but they seem to me to have a kind of different kind of valence. And they don't actually grow out of the old, most of these do grow out of the old 4-part test. Those 2 are like something else, and they felt different. I mean, they felt reasonable, but they felt like they were, although they were written in the positive, they were really the absence of negatives. And at the risk of proliferating more subsections, you might want to have that as they were different. They were not reasons to grant so much as the absence of reasons not to grant.
Well, I mean, one thing is, should we make that a rule?
Well, as opposed to a factor, I don't know.
Yeah, I mean,
But
just
they felt
throwing
different.
it out
To me,
there.
they felt different.
It felt, to me, it felt differently, like, you should recuse yourself.
Yeah.
If you're applying, you'd be applying for a job somewhere, you should recuse
Yeah.
yourself.
Well, I mean, you've correctly identified that it was quite difficult to draft those as
Yeah.
positives. They were initially
I mean,
drafted.
my sense was that, with the exception of 7, which I couldn't tell which way it went, they were all drafted as pluses.
Yes.
I actually was confused about 7. Was that bad or good? Is that that it's new?
It was 7 was intended to be a
We
negative.
need to take a pause.
Say that again, Chad.
7 was intended to be a negative, a
Yeah.
strike against the requester. With respect to moving 3 and 10 out of the sections and addressing them sort of separately, we can attempt that. That's not difficult.
It's more of a thought than a directive, if you will, but just think about it.
Yeah.
In terms of as this gets organized, if we're gonna try and move a little bit closer to the old model without being wedded to those 4 specifics, but things that more clearly grow out of it. But these are different considerations, whether they should be in the rule or not. I would put them in a different place.
The issue about undue delay was quite strongly stated by the board in
Okay.
some of its
Okay.
recent advisory opinions about
Okay.
post-employment waivers, especially because the risk is that a person
Right.
has left public service,
Right.
they're already in the new job,
Right.
and they're easier.
We're kind of sandbagged into
Right.
it.
There's either the potential for a continuing violation or
Yeah.
potentially this person cannot keep their
Yeah.
job.
Yeah.
So to require people to come to us without undue delay or even
Yeah.
before they leave prevents that from happening.
3 is also a violation.
Yes.
Yeah.
So I
That's
don't
what
know.
I was saying.
Yeah,
Why don't we
yeah.
just make it
You're
a
absolutely
rule?
right. It's a
It's not a rule, I
it's a
mean-
violation of 2604 D1.
That's right.
And,
So-
but the idea here is essentially to say, if you have, like, it might be the case that there might be a circumstance where the board would want to grant a post-employment waiver even though the person violated D1. It might happen. It might be that it's important for the city to do that, and the board might choose to do it.
They're so unique, they're the only ones who
It could
can
be,
do it.
and so we didn't want to, write a rule that prohibited the board from doing so. The board could in fact engage in enforcement action and give somebody a waiver, a post-employment waiver at the same time. I'm not suggesting that it's likely, but
Yeah, we
but,
could just leave that out.
but the idea being,
It would
that
require
might
some
be
sort of
something that the
affirmative
board.
statement that there has been no violation of D1 as part of the request for the waiver to
We
require an
could do
affirmative
that, we could do
representation.
that anyway, without putting that.
Well, there's no harm putting in a rule, I guess, but it's more to, I think that, it sounds like the biggest thing that's missing is the competitive harm.
Mhm.
Right.
And that we didn't, I take it it was not intended to drop that as a concept, question mark?
Well, we were trying to capture it sort of more granularly in maybe 7 and 8 here.
Right, so to sort of address that, like, in how we were thinking about it. to
But
be-
I think we haven't quite hit the
Eight
target
is
on
really
that.
obscure on
Yeah,
that.
so-
And 7, I must admit, I was kind of baffled by which way 7 cut. Was it good or bad that these were new things? I actually couldn't tell.
Oh.
The way I read it was
Yeah.
that it's bad if you are going to a new employer and generating them new work.
I guess,
that they
and
otherwise
certainly it's,
couldn't do.
That's right.
and certainly it's inconsistent with the finishing up of old work, which I think we saw earlier. Or do we? I don't even know.
That's in the
factoring
consulting
into
back.
Post-employment, yeah, right. So, I don't know. I also do wonder, I think both in here and later when we talk about the consulting back, the very specificity of 60 days as opposed to a relatively short period, because 60 days, as later we use 6 months, it does seem to be pulled out of thin air. And at the risk of giving less specific guidance, I would be more comfortable with something that says a relatively brief period of time, and maybe in the statement referencing one where we used, I remember the substitute teacher one,
Right.
things like that.
So that came out of some confidential board advice to some
Yeah.
public servants, but that was actually raised by one of the comments from an individual board member, and when we totally agree, it should just say like a very short period of time
Yeah.
or something like that.
Right. 60 days is because it's the most ready to hand, but there's no reason to be.
But if it was
married to
90
that.
days, I think I'd feel the same way,
Right.
and possibly 120, I don't know where the line is.
Depends on the nature of the
Yeah,
job.
yeah.
Right,
That's
so
right.
it's just one factor of many that the board would evaluate, consider, and so it could just say very short period of time.
And so, in some way, that one on 8, I think, 8 and 9, I think relate to the idea that the person is not getting much advantage in terms of inside information, not just confidential, but the inside workings of the agency.
Yeah.
That it's a different unit, and you might wanna put it that way, rather than the specifics of 8 and 9, but that's just a thought, under the circumstances. And with those two being examples of the ways in which the person is not taking advantage of a lot of inside information. It's a different unit of a big agency, or they were only there for a short time. Just,
Those seem
but-
like the potential harm to the city though. Like if you were somehow shortening the list of factors to be broader, broader factors. These are examples of why there's less
Yeah.
potential harm. You've only been there for a short time, or there's no competitive disadvantage.
I think of it also for competitors, right?
Right,
It's
that you
both,
can give examples.
both misuse of inside information and less disadvantaging competitors, but,
Yeah.
but I would talk about it, maybe I'm running out of words that way with these. 8 and 9, I think, are subsets of this other concept, which is that it's less of a revolving door problem if you're not bringing much information, much relevant information with you. Whether it's because of misuse of inside information or the advantage over competitors.
I think we were trying to capture in that factor, Richard, not so much the information, but the human beings that you dealt with
Mhm.
before.
The
like-
relationship.
The relationship.
Right,
Same
right.
concept.
Well,
The
that's part of the
actual-
information.
Right.
It's just, it's, right, you're right, it's also they'll take my phone calls before they'll take somebody else's who we're friends.
Exactly
But,
right.
but it's the inside,
former boss.
let's call it the inside connection.
Yeah.
Whether
Yeah.
it's because I know how that agency works, and I know the right person to call is X, even though the formal chart says Y, and also because X will take my call because we used to have coffee together. It's both.
Okay.
Well, I don't know if we gave you any guidance on this, but think about it.
Don't come back with like now 20 factors. That's not, I don't think that's where
If
we're
anything,
going.
it'll be
Right.
I think the major goal would be to relate it more to what we've done before, but I think keeping a number of these things, particularly, I think in the 4, 5, 6 area, I think is right. And I think often as we've applied the 4-part test, we've actually have focused on certain things over and over again. In particular, 4 and 5, we come at all the time, and it might be worth, I think it's probably worth actually putting those in.
Those seem like the same to me, just examples of the same concept.
Well, one is the unique benefit to the city, so this is the person who ran the such and such engineering project for the last 20 years, and the city wants to keep using that person. And the other is when, even though there might be other people in the agents, maybe that relates more to the consulting back, maybe that's the consulting back issue.
Yeah, this is, the distinction between the two is one is you're the only technical expert on this thing. The other is at your new private employer, there are
There's
5
nobody
people
else.
who work
So
there
they're
and
all
nobody else
unique,
has
but
time to
it's
do
still
it.
the uniqueness of this
It's-
person for the job.
Well, the person's, in one
different.
case,
different
unique
kinds
because
of
they have
uniqueness.
technical, right.
That's why it's unique.
But by articulating different types of uniqueness, the
Right.
idea would be to sort of provide the board with the information it needs to
Right.
evaluate a request in its totality.
Yeah.
Just because many requests come to us, and this person's
No,
this
they
thing,
always
they're
say,
always
this person's
unique.
the only person who can do
And
this,
they're
or this person's the only person who's done this.
And then by providing sort of the more specific information, the board can evaluate each request sort of more
Right.
on its
I just
genuine
think 4 and
merits.
5 are the same concepts, just different ways of, I guess, evaluating whether that is present or not, but it's the same. Why does this person need the waiver? Because this is the only person who can do it. That's why you want the waiver.
The idea of 4 would be to take into account sort of the nature of the entity, that if, for example, there's a type of entity that the city has a real history of working with, and it's a very small entity,
Right.
and the entity hires a person to perform a certain type of work,
But
perhaps this person
There's no one else
isn't,
who could do
Right,
it.
right.
if this person's not a nuclear physicist, their skills are not unique in the technical sense, but at the entity with which the
It's
city has
two-person
chosen to have
entity.
this relationship, they are unique. And it's to
No, I
articulate.
get it, it's just, I'm not sure it merits a whole separate section.
It comes up a lot, actually, and I think, come back, I'm not there.
Uniqueness, it's not, it's an example of what I feel like when we put so many factors breaking out based on what's happened already, inevitably, what's gonna happen is there's gonna be another different thing that comes along, and now it's not one of the enumerated factors, because this doesn't even say including, it says, this
Right.
is what we consider.
Right, we
So
intend
would propose
to
we would
change that.
propose to revise it to say including.
So then, once you get to including, you don't need to list 75 factors then.
But then I think it's also useful for us, frankly. I think we have struggled with these a lot. And I think I've found that the 4-part test doesn't really map on what we consider. I mean, it does and it doesn't. It maps on
Yeah.
partially. It
And
maps
we
on
try
like
to
3/4.
squeeze things into it. We
And so
try to-
I actually think
right.
this is as useful for us as it will be for applicants to actually have this in front of us.
The goal would be to structure the requests in a way that we have the opportunity to structure the sorts of requests and the factors that people are
Yeah, it would be
articulating in
nice
their
for people
requests.
to be able to look and find their factors.
Right,
Yeah.
and frankly, helping, it also guide staff in
Yeah.
terms of what questions we're asking before we bring the
Right.
matter to the board.
I have a slight kind of linguistic question. The rules about appearances, but the waiver language, sometimes you use appear, sometimes you use communicate, and sometimes you use work. And I'm not sure whether work is prohibited if it doesn't involve an appearance.
With particular matters, it would.
Would we, okay, we can't work on it, it's not just appearance, okay. And again, is communicate different from appear?
No.
No.
Then maybe you should use appear whenever possible. I mean, I know some are work, some are appear, some are communicate. I'd like to be as close to the charter language as we can.
Yep.
D, consulting for a former agency. And there, I had, well, work is one, but if work is the problem, then work is the problem. That's like on line 4 and other places. The 2 questions I had were, the consulting arrangement will not exceed 6 months. That's very specific. Is there an AO that we specifically have done that in, or this is the pulled out of your hat problem? 6 months, there's something to, if there's a reason for 6 months, I'd like to know, otherwise I'm not, it does seem arbitrary. And the other, on the line, on page 18, line 3, after written approval of the head of the city agency, the board determines the proposed consulting arrangement will provide a substantial benefit. Is this bigger than the benefit on page 15, line 15? Is substantial meant to be more than just a benefit?
The benefit that's in here does not come.
Okay, in other words, the consulting back is not a higher level of benefit than the usual waiver. Okay,
No.
so let's take out substantial.
So on the 6-month thing, you are correct in that we pulled that period of time out of our hat. The concept of it, however, was to try to get at, because these are consulting back circumstances that the board will not see, right? The only approval requirement there
Right.
is for the agency head to
Right,
approve
okay.
it. So the idea was a little bit to keep that sort
Okay.
of narrow, but with the idea being that these are really for former public servants who are finishing up projects and doing this as a consulting.
David wrote your PDR.
It's not, the time period could be different. We could address that problem in some different way. We welcome.
But I guess if it was a year at that point, it would then turn it, then the matter would end and they could do it.
Well,
I guess maybe the particular matter ban.
right, yeah, the particular matter ban is a lifetime ban. And so
Right,
if the
right.
person is working on something that they worked on when they were in public service, which is the concept
Right.
here, then that's
Right.
for the duration of that
I
particular
mean,
matter.
I'm really against it so much as trying to sort of justify the specificity of it, but also I understand that there's a value to specificity as opposed to not be very long, which is hopeless. So I guess I'm okay with it, but I'd like to hear
You know, we've
more.
used an articulation, I guess, where you're, in the travel context, where you cannot travel longer than is necessary to do the work. And maybe, I don't have the words here now, but maybe only for as long as is necessary to complete the specific project for which the employee has been retained, something of that sort.
Right.
You know,
If it's a
which
construction
is,
project, it could be a
yeah.
decade.
Well,
Thank God forever.
That's something that we could try to
something,
encapsulate.
because we've done that in
Yes.
other contexts.
Yeah, we'll take a crack at some other options.
And if, has this come up in any of our published AOs or anything like that? Any kind of reference to the time limit?
Because this is an interpretation of
Right.
D6, no public documents
Right.
are produced, no waivers are produced when people come to us, whether or not their behavior comports with D6, because the board is not issuing a waiver, the board is interpreting the government-to-government exception. So there's actually not as much public guidance about this as in other parts of the code.
And actually, now that I think about it, why does it matter that it's time limited? If it already satisfies completing unfinished work and has special skills and the compensation level is the same as before, why would it be a problem if the guy continued to work for 2 more years?
Right, it's primarily just intended to try to, look, the idea here is you're using the government-to-government exception as a way of leaving public service and then doing business with your former city agency, which on the face of it seems like it would be prohibited by Chapter 68, but we're saying because of the government-to-government exception, you're really continuing to work as a government employee here. But I think when the board issued the AO about this, the board was very concerned that former public servants were gonna get sweetheart deals doing this sort of thing. So, so it was,
Compensation piece.
right, so it was trying to limit, what the scope of that would be. Maybe, but, we may have missed the mark on the time thing, but
These
it's.
are people, some of them, if they've retired, they're presumably getting pensions as well? Or is there a problem with their getting a pension and being a consultant?
I don't know whether there's a problem with them getting a consultant and being a consultant, getting a pension, but they're not all retired. A lot of them are people who have left city service for other reasons.
And open to business.
Right, and it's if they've opened a business and that business
Then
is
they
doing
can-
that thing, then
then
we're
they can
pretty
do it.
sure that it's not this, but often it'll be someone who, for one reason or another, cannot continue as a public servant. For example, they need to move to some other location outside of the city for family reasons or whatever, but they would like to continue to wrap up the thing that they've been working on so they don't leave their agency in a lurch. That's sort of the idea. But again, maybe this time concept misses the mark.
Well, maybe, we're obviously gonna come back to this, so if people have more thoughts about the time limit between now and the time we come back, either communicate it directly to Ethan and Chad. I could see it, I could also see not doing it, especially since we have both the first point about finishing up former work and the unique skills and the same compensation level and the agency approval. It does seem like one way to close the back door, but on the other hand, it seems like, well, maybe this is, and if all the other elements are met, maybe this is a back door that doesn't need closing. I'm not, I don't know the answer. Further comments on D?
On D, I'm not, I guess Romanet 1 on line 21. I guess we did talk, and I guess the idea here is if you're working for an employment agency. I don't know that it quite says that. The subsequent employer was selected by the city.
Right,
The
so,
situation this most often comes up in is when an agency has a pre-existing temporary
Yeah.
staffing arrangement with an employer, but this Romanet 1 is actually slightly broader than that, is that any subsequent employer could be chosen by the city, as long as the city is the one choosing the subsequent employer, not necessarily the public servant.
I understand that, it just reading this, I'm not sure people quite understand the subsequent public employer. There may not be a public employer, a private employer, the subsequent employer may just be yourself, which would in most cases be the case. And if it were a firm you were working for, that's another matter entirely, isn't it? That would be.
no, this is, the concept of this from the advisory opinions, is that this is like the consulting back arrangement, but for the fact that for administrative convenience, the city is using usually a pre-existing contract with a temporary employment agency to administer the payments. But that takes it out of the realm of one, the consulting back, where you are just as an
Just the
individual,
individual.
right? And now you are working for an employer. You should be technically in the regular post-employment thing. You're working for a firm that's now doing business with the city. And the idea here is when the city is just doing that for the administrative convenience, it's the easiest way to pay the person, that you need a waiver to do it, but here's the standard for doing that. It's not gonna be the regular, stricter waiver standard. It's gonna be this one that gets at that specific issue. That's the concept from the advisory.
I understand the
opinions. Yeah, oh,
concept, I'm just not certain that this says that.
We can,
I just, somebody looking at this would not
What's the
know that.
question?
can I rephrase it and maybe
Yeah.
see if I can, yeah, okay, so
Yeah.
I think, and you can tell me if I've got this right, that just, under 2 Romanet 1 on line 21 and 22 of Exhibit 1, page 17, that doesn't capture clearly, right? If you're just reading it, it doesn't capture clearly the idea that what's happening is that the city is picking a firm for you to work at for its administrative convenience in this consulting back sort of but-for scenario, and that we could phrase this in a way that made that clear that that's what the intent of this is. And we're happy to try to take another
Isn't
shot.
just, if we just use private firm instead of subsequent employer, doesn't that, is that?
Does this work for all private firms, though? I understand it for some kind of employment supplier, but if someone went to a firm, for example, if I were working and then went off to a firm, and could my agency then contract with the firm for my services during that period?
Under this rule, only with the board's approval.
So it could be Kelly Temps or it could be a law firm. It doesn't matter. It could
So,
be
but
any
this is the
company.
board's approval is required.
The board's
For,
approval is
for
required.
2, yeah.
On
Two.
Romanet 2 on the top of the next page.
Absent the board's approval, it would be prohibited.
That's what
Okay,
it says.
that's okay.
Makes sense.
So then a private.
Yes, and any private,
Subsequent.
any private entity.
Yes.
Okay.
Further comments on this draft? Hearing none, I am gonna call for a motion that the board continue this discussion at a future board meeting.
So moved.
A second. All in favor? Any opposed? The motion for continuation of discussion has passed. We have one more item. This is the proposed amendments to Board Rules 101H, the gift of travel. Oh, the gift of travel. Chad, sorry. Chad, any opening thoughts for us?
So, the board reviewed this at its last meeting in December, and staff received some comments, and attached at 3 is a clean version of the proposed notice of opportunity of public hearing and comment, where it incorporates the board's comments from the previous meeting, and it's accounting for all the AOs, it's additional language that clarifies how the mixed purpose travel will work, and it includes the definition of agency and approval.
We've been through this before, we made some specific comments, they've all been included. I have one incredibly minor comment on page 6. I was thinking it gives me the opportunity to use the word Romanet one more time. Of Exhibit 2, Romanet 4. on the very first word, the article should be the and not of, because we're talking about the public servant who is taking the trip, making the travel arrangements. And elsewhere in the rules, when we start talking about specific one, we use the. So it's a public servant may accept if that public servant's agent received agency approval. That is, since I could say Romanet one more time, but that was my only comment, otherwise it looked like it fully reflected all of the suggestions that were raised at the prior reading. Any further comments? Okay, I now call for a motion that the board adopt the recommended amendment to Board 1-10H with that one very minor change I made as the final rule.
So,
Any seconds?
Second.
All in favor?
Aye.
Any opposed? The motion for the adoption of the proposed amendments with that very minor change as presented as the final rule has passed. Our open meeting is now concluded. Thank you very much.